This is an ABC News special, The Mueller Report. Here now, George Stephanopoulos.
Good morning. We are coming on the air right now because the Attorney General of the United States, William Barr, is about to hold a press conference right there at the Department of Justice ahead of the release of Special Counsel Robert Mueller's report on President Trump and Russian interference in the 2016 election. That is going to come later this morning when it will be sent to Congress. But first, we are going to hear from the Attorney General, William Barr, on the process he's gone through in redacting this Mueller report. I want to go to our chief White House correspondent, John Carr, who's there in our newsroom where our teams of reporters are going to be reading the report during the day. John, what do we expect to hear first from the Attorney General?
The Attorney General is going to go over three things, George. First of all, whether or not executive privilege was asserted by the president to remove any information, redact any information in this report. As of yesterday, we were told the answer to that is no. Secondly, he is going to talk about any conversations the Justice Department has had with the White House about the substance of the report. As we first reported here on ABC, there have been conversations described to me as broad brushstrokes descriptions of the report. The interesting thing will be whether or not anything over the last several hours has happened as the White House received a further briefing on the details of the report. And finally, George, he will explain the redaction process, what he blocked out of this report and why.
We will know it soon enough. Meantime, Mary Bruce, our senior congressional correspondent, Democrats already outraged by the fact of this press conference alone. House Speaker Nancy Pelosi saying this causes a crisis of confidence in his independence and impartiality.
Yeah, George, Democrats are furious at the fact that the press is being briefed on this before they themselves have even had a chance to read this. And here is the Attorney General.
Rosenstein.
Good morning, everybody, and thanks for being here this morning. As you know, on March 22nd, Special Counsel Robert Mueller concluded his investigation into matters related to Russian attempts to interfere in our 2016 presidential election, and he submitted his confidential report to me pursuant to department regulations. As I said during my Senate confirmation hearing and since, I'm committed to ensuring the greatest degree possible of transparency concerning the special counsel's investigation, consistent with the law. At 11 this morning, I'm going to transmit copies of the public version of the special counsel's report to the chairman and ranking members of the Senate and House Judiciary Committees. The Department of Justice will also make the report available to the American people by posting it on the department's website after it has been delivered to Congress. I'd like to make a few comments today on the report. Before I do that, I want to thank Deputy Attorney General Rod Rosenstein for joining me here today and for his assistance and counsel throughout this process. Rod, as you know, has served at the department for nearly 30 years with dedication and distinction, and it's been a great privilege and pleasure for me to work with him since my confirmation. He had well-deserved plans to step back from public service that were interrupted by my asking him to help in my transition. Rod has been an invaluable partner, and I am grateful that he is willing to help me and has been able to see the special counsel's investigation through to its conclusion. Thanks, Rod. Thank you. Yeah. I'd also like to thank Special Counsel Robert Mueller for his service and the thoroughness of his investigation, particularly his work exposing the nature of Russia's attempts to interfere in our electoral process. As you know, one of the primary purposes of the Special Counsel's investigation was to determine whether President Trump's campaign or any individual associated with it conspired or coordinated with the Russian government to interfere in the 2016 election. Volume 1 of the Special Counsel's report describes the results of that investigation. As you will see, the Special Counsel's report states that his quote, investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in its election interference activities. I am sure that all Americans share my concern about the efforts of the Russian government to interfere in our presidential election. As the special counsel report makes clear, the Russian government sought to interfere in our election process. But thanks to the special counsel's thorough investigation, we now know that the Russian operatives who perpetrated these schemes did not have the cooperation of President Trump or the Trump campaign, or the knowing assistance of any other American for that matter. That is something that all Americans can and should be grateful to have confirmed. The special counsel report outlines two main efforts by the Russian government to influence the 2016 election. First, the report details efforts by the Internet Research Agency, a Russian company with close ties to the Russian government, to sow social discord among American voters through disinformation and social media operations. Following a thorough investigation of this disinformation campaign, the special counsel brought charges in federal court against several Russian nationals and entities for their respective roles in this scheme. Those charges remain pending, and the individual defendants remain at large. But the special counsel found no evidence that any American, including anyone associated with the Trump campaign, conspired or coordinated with the Russian government or the IRA in this illegal scheme. Indeed, as the report states, quote, the investigation did not identify evidence that any U.S. person knowingly or intentionally coordinated with the IRA's interference operation, unquote. Put another way, the special counsel found no collusion by any Americans in IRA's illegal activities. Second, the report details efforts by the Russian military officials associated with the GRU, the Russian Military Intelligence Organization, to hack into computers and steal documents and emails from individuals associated with the Democratic Party and Hillary Clinton's campaign for the purpose of eventually publicizing these documents. Obtaining such unauthorized access into computers is a federal crime. Following a thorough investigation of these hacking operations, the special counsel brought charges in federal court against several Russian military officers for their respective roles in these illegal hacking operations. Those charges are still pending, and the defendants remain at large. But again, the special counsel's report did not find any evidence that members of the Trump campaign or anyone associated with the campaign conspired or coordinated with the Russian government in these hacking operations. In other words, there was no evidence of the Trump campaign collusion with the Russian government's hacking. The special counsel's investigation also examined Russian efforts to publish stolen emails and documents on the internet. The special counsel found that after the GRU disseminated some of the stolen documents to entities that it controlled, DC Leaks and Guccifer 2, the GRU transferred some of the stolen materials to WikiLeaks for publication. WikiLeaks then made a series of document dumps. The special counsel also investigated whether any member or affiliate of the Trump campaign encouraged or otherwise played a role in these dissemination efforts. Under applicable law, publication of these types of material would not be criminal unless the publisher also participated in the underlying hacking conspiracy. Here, too, the special counsel's report did not find that any person associated with the Trump campaign illegally participated in the dissemination of the materials. Finally, the special counsel investigated a number of links or contacts between the Trump campaign officials and individuals connected with the Russian government during the 2016 presidential campaign. After reviewing these contacts, the special counsel did not find any conspiracy to violate U.S. law involving Russian-linked persons and any persons associated with the Trump campaign. So that's the bottom line. After nearly 2 years of investigation, thousands of subpoenas, hundreds of warrants, and witness interviews, the special counsel confirmed that the Russian government sponsored efforts to illegally interfere with the 2016 presidential election, but did not find that the Trump campaign or other Americans colluded in those efforts. After finding no underlying collusion with Russia, the special counsel's report goes on to consider whether certain actions of the president could amount to obstruction of the special counsel's investigation. As I addressed in my March 24th letter, the special counsel did not make a traditional prosecutorial judgment regarding this allegation. Instead, the report recounts 10 episodes involving the president and discusses potential legal theories for connecting those activities to the elements of an obstruction offense. After carefully reviewing the facts and legal theories outlined in the report, and in consultation with the Office of Legal Counsel and other department lawyers, the Deputy Attorney General and I concluded that the evidence developed by the special counsel is not sufficient to establish that the president committed an obstruction of justice offense. Although the Deputy Attorney General and I disagreed with some of the special counsel's legal theories and felt that some of the episodes examined did not amount to obstruction as a matter of law, we did not rely solely on that in making our decision. Instead, we accepted the special counsel's legal framework for purposes of our analysis and evaluated the evidence as presented by the special counsel in reaching our conclusions. In assessing the president's actions discussed in the report, it is important to bear in mind the context. President Trump faced an unprecedented situation. As he entered into office and sought to perform his responsibilities as president, federal agents and prosecutors were scrutinizing his conduct before and after taking office and the conduct of some of his associates. At the same time, there was relentless speculation in the news media about the president's personal culpability. Yet, as he said from the beginning, there was, in fact, no collusion. And as the special counsel's report acknowledges, there is substantial evidence to show that the president was frustrated and angered by his sincere belief that the investigation was undermining his presidency, propelled by his political opponents, and fueled by illegal leaks. Nonetheless, the White House fully cooperated with the special counsel's investigation, providing unfettered access to campaign and White House documents, directing senior aides to testify freely, and asserting no privilege claims. And at the same time, the president took no act that in fact deprived the special counsel of the documents and witnesses necessary to complete his investigation. Apart from whether the acts were obstructive, this evidence of non-corrupt motives weighs heavily against any allegation that the president had a corrupt intent to obstruct the investigation. Now, before I take questions, I want to address a few aspects of the process for producing the public report that I am releasing today. As I said several times, the report contains limited redactions related to 4 categories of information. To ensure as much transparency as possible, those redactions have been clearly labeled so that the readers can tell which redactions correspond to which categories. Now, as to recall, those categories are 6E material, grand jury material, information that the IC believes would disclose sources and methods, information that would impair the investigation and prosecution of other cases that are underway, and finally, information that implicates the privacy and reputational interests of peripheral third parties. As you will see, most of the redactions were compelled by the need to prevent harm to ongoing matters and to comply with court orders prohibiting the public disclosure of information bearing on ongoing investigations and criminal cases, such as the IRA case and the Roger Stone case. These redactions were applied by Department of Justice attorneys working closely together with attorneys from the special counsel's office, as well as the intelligence community, and prosecutors are handling the ongoing cases. The redactions are their work product. No redactions done by anybody outside this group. There were no redactions done by anybody outside this group. No one outside this group proposed any redactions, and no one outside the department has seen the unredacted report, with the exception of certain sections that were made available to IC, the intelligence community, for their advice on protecting intelligence sources and methods. Consistent with longstanding executive branch practice, the decision whether to assert executive privilege over any portion of the report rested with the President of the United States. Because the White House had voluntarily cooperated with the special counsel, significant portions of the report contained material over which the President could have asserted privilege, and he would have been well within his rights to do so. Following my March 29th letter, the Office of the White House Counsel requested the opportunity to review the redacted version of the report in order to advise the President on the potential invocation of privilege, which is consistent with longstanding practice. Following that review, the President confirmed that in the interest of transparency and full disclosure to the American people, he would not assert privilege over the special counsel's report. Accordingly, the public report I am releasing today contains redactions only for the 4 categories that I previously outlined, and no material has been redacted based on executive privilege. In addition, earlier this week, the President's personal counsel requested and was given the opportunity to read a final version of the redacted report before it was publicly released. That request was consistent with the practice followed under the Ethics in Government Act, which permitted individuals named in a report prepared by an independent counsel the opportunity to read the report before publication. The President's personal lawyers were not permitted to make and did not request any redactions. In addition to making the redacted report public, we are also working with Congress to accommodate their legitimate oversight interests with respect to the special counsel's investigation. We have been consulting with Chairman Graham and Chairman Nadler through this process, and we will continue to do so. Given the limited nature of the redactions, I believe that the publicly released report will allow every American to understand the results of the special counsel's investigation. Nevertheless, in an effort to accommodate congressional requests, we will make available, subject to appropriate safeguards, to a bipartisan group of leaders from several congressional committees, a version of the report with all redactions removed, except those relating to grand jury information. Thus, these members of Congress will be able to see all of the redacted material for themselves, with the limited exception of that which, by law, cannot be shared. I believe that this accommodation, together with my upcoming testimony before the Senate and House Judiciary Committees, will satisfy any need Congress has for information regarding the special counsel's investigation. Once again, I'd like to thank you for being here, and I will now have a few questions.
Mr. Attorney General, we don't have the report in hand, so could you explain for us the special counsel's articulated reason for not reaching a decision on obstruction of justice, and if it had anything to do with the department's long-standing guidance on not indicting a sitting president? And you say you disagreed with some of his legal theories. What did you disagree with him on?
I'd leave it to his description in the report, the special counsel's own articulation of why he did not want to make a determination as to whether or not there was an obstruction offense. But I will say that when we met with him, Deputy Attorney General Rosenstein and I met with him, along with Ed O'Callaghan, who is the principal associate deputy, on March 5th, we specifically asked him about the OLC opinion and whether or not he was taking the position that he would have found a crime but for the existence of the OLC opinion. And he made it very clear several times that that was not his position. He was not saying that but for the OLC opinion he would have found a crime. He made it clear that he had not made the determination that there was a crime.
Did you disagree with him on?
May I follow up on that, Mr. Attorney General?
What did you disagree with him on?
Given that, why did you and Mr. Rosenstein feel the need you had to take it to the next step to conclude that there was no crime, especially given that DOJ policy?
Well, the very prosecutorial function and all our powers as prosecutors, including the power to convene grand juries and the compulsory process that's involved there, is for one purpose and one purpose only. It's determine yes or no. Was alleged conduct criminal or not criminal? That is our responsibility, and that's why we have the tools we have. And we don't go through this process just to collect information and throw it out to the public. We collect this information, we use that compulsory process for the purpose of making that decision. And because the special counsel did not make that decision, we felt the department had to, and that was a decision by me and the Deputy Attorney General. Yes.
Or did the special counsel indicate that he wanted you to make the decision or that it should be left for Congress? And also, how do you respond to criticism you're receiving from congressional Democrats that you're acting more as an attorney for the president rather than as the chief law enforcement officer?
Well, Special Counsel Mueller did not indicate that his purpose was to leave the decision to Congress. I hope that was not his view, since we don't convene grand juries and conduct criminal investigations for that purpose. He did not. I didn't talk to him directly about the fact that we were making the decision, but I am told that his reaction to that was that it was my prerogative as Attorney General to make that decision.
Attorney General Barr, Catherine Herridge, Fox News. Hi there. Is there anything you can share today about your review of the genesis of the Russia investigation and whether assets have been provided to investigate?
No, today I'm really focused just on the process of releasing this report.
Attorney General, senior Democrats in Congress have asked for Robert Mueller himself to testify. Robert Mueller remains a Justice Department employee as of this moment. Will you permit him to testify publicly to Congress?
I have no objection to Bob Mueller personally testifying.
Mr. Attorney General, it's not just Democrats who have questioned some of the process here. A Republican-appointed judge on Tuesday said you have, quote, created an environment that has caused a significant part of the American public to be concerned about these redactions. You cleared the president on obstruction. The president is fundraising off of your comments about spying. And here you have remarks that are quite generous to the president, including acknowledging his feelings and his emotions. So what do you say to people on both sides of the aisle who are concerned that you are trying to protect the president?
Well, actually, the statements about his sincere beliefs are recognized in the report, that there was substantial evidence for that. So I'm not sure what your basis is for saying that I am being generous to the president.
You face an unprecedented situation. It just seems like there's a lot of effort to go out of your way to acknowledge how this.
Well, is there another precedent for it?
No, but it's unusual.
Okay, so unprecedented is an accurate description, isn't it?
Yes. But
Okay.
what do you say to people who are concerned that you are trying to protect the president?
Eric?
There's a lot of public interest in the absence of the special counsel and members of his team. Was he invited to join you up on the podium? Why is he not here? This is his report, obviously, that you're talking about today.
No, it's not. It's a report he did for me as the Attorney General. He is required under the regulation to provide me with a confidential report. I'm here to discuss my response to that report and my decision, entirely discretionary, to make it public, since these reports are not supposed to be made public. That's what I'm here to discuss.
Impropriety for you to come out and sort of what appears to be sort of spinning the report before the public gets a chance to read it?
Okay, thank you very much. Thank you.
Well, there you have it right there. Attorney General William Barr just finishing his press conference laying out his interpretation of the conclusions of Robert Mueller's, Special Counsel Robert Mueller's report. Extraordinary press conference there by the Attorney General, not just on the process that he went through in redacting this report by Robert Mueller, but also laying out again his conclusions. And you saw him facing questions there already raised by Democrats that this puts his impartiality into question. I want to start out with our chief legal analyst, Dan Abrams, right here. Pretty extraordinary right there at the start, Dan Abrams, how basically William Barr again summarized what he thought the conclusions of Robert Mueller's report are, even though over the last 700 days we haven't heard from Robert Mueller himself.
Right, and again and again and again repeating this notion that there wasn't, what the evidence didn't show, that the evidence didn't show collusion. And basically, he would take the legal term conspiracy and then say, so what this really means is that there's no collusion. Now, that's where he gets into dangerous territory, right? You can say Robert Mueller's report found there was no conspiracy with the Russians to interfere in the election. When you then start summarizing what that means, you're now going to a different level. And I think that's the danger for him here. And it didn't just happen there. You heard that reporter there asking him some tough questions about whether he was talking about his emotions and his feelings. He talked about the context. He said, let's put this into context for a moment. Why is the Attorney General putting it into context? So that's...
Well, he has that phrase that the president was facing an unprecedented situation. Of course, several presidents have been investigated in the past. I want to hold on right here because Pierre Thomas was there in the room with the Attorney General. Seemed to be kind of tense in there, Pierre.
It was. I mean, you know, the bottom line is that the Attorney General sought to lay out orally what he had said in that letter that he'd written several weeks ago. I was struck by the fact that he talked about the fact that there was, in fact, an attack by the Russians. He tried to make that clear, that there was an attack, making clear that it wasn't a witch hunt, although he did not use those words. But as you said, he put forth a very spirited explanation, his interpretation of what Mueller found, and he sought to make it very clear that there was no collusion, and he wanted that presented, and basically wasn't hearing complaints that he was operating to protect the president. He was basically saying, this is what was found, and you'll soon see it for yourself.
And thank you, Pierre. And Terry Moran, also here, our chief national correspondent. Of course, he also laid out his conclusions of Robert Mueller's conclusions on obstructions. There was more daylight, apparently, between Robert Mueller and the Attorney General than there may have been on the question of collusion.
That's right. They disagreed, or Robert Mueller was not going to take a position on whether or not the evidence that he had gathered could amount to obstruction of justice by President Trump. And it's Bill Barr, the Attorney General, who decided to step into that breach and read the evidence through his lens, the lens that he shared with us, almost like a lawyer making a closing argument. I think that's worth pointing out. This is such a big day. Here's this matter that concerns the confidence of the country in the election and the president that has belonged up until now to the lawyers, to the investigators and the lawyers and Justice Department officials and the president's lawyer. Today, it belongs to the entire citizenry. And this sounded like an effort to make an argument to that citizenry.
One of the big questions, Kate Shaw, also a legal analyst, was asked is whether or not Robert Mueller intended that evidence he constructed on obstruction to go to the Congress without a decision by the Attorney General.
Right, and it's not totally clear what Special Counsel Mueller intended Barr to do, right? He definitely didn't say to the Attorney General, I'm passing the ball to you, you make a determination, right? It seems as though the evidence in the report is allowed to speak for itself, and we know there are 10 possible acts by the president that the Attorney General referenced that are considered as possibly constituting obstruction of justice. Now, no decision gets made, but Attorney General Barr, of course, steps into the breach and says, as a legal matter, these acts don't constitute obstruction of justice. And we saw this very kind of impassioned defense of the president's conduct as needing to be understood within the lens of he's frustrated, he's angry, he knows there was no collusion. It really did feel, I think, as Terry just said, like a personal lawyer making a defense of a client as opposed to a chief law enforcement officer.
And Dan Abrams, that, of course, gets to the question of intent on obstruction of justice.
Right, and there was a very important question asked of him, whether the Office of Legal Counsel memo, which in 2000 found that a sitting president shouldn't be indicted. And the question was that one of the reasons that Robert Mueller didn't make a decision on obstruction of justice? He wouldn't answer whether he said that in the memo itself, which to me indicates there was some mention of it in the memo. But he did then say, but When I spoke to him about it, he said it wasn't but for, meaning he confirmed that he wasn't ready to indict but for the Office of Legal Counsel guidance. And there's a difference there. If Robert Mueller mentioned that as one of the factors, if one of the factors in not making a decision was, well, a sitting president can't be indicted anyway, that's really important, even if it wasn't but for.
And that's one of the questions that, of course, Congress will have to consider after they read the report. I want to go back to Pierre as well. Pierre, one of the oh, I'm sorry. I guess he's going to now read the report, which we should be seeing soon. Cecilia Vega, already President Trump has come out and responded to William Barr's press conferences. Is likely to fuel the concerns that Democrats have.
Exactly, and I think there's probably no question that the audience of one, President Trump, was watching this. We know he tends to be watching TV at this hour in the morning, so he's got a tweet out right after Barr wrapped saying no collusion, no obstruction, game over. It's a Game of Thrones reference, actually. We can't emphasize enough the extraordinary nature of what we just witnessed this morning. It's not just going to be from Democrats. I wouldn't be surprised if we start to hear some concerns coming from Republicans on Capitol Hill about what we just witnessed. This was the Attorney General seeming to defend how the president was feeling going into this, talking about his frustrations and his anger. And I also want to point out, this wasn't William Barr just laying out the procedures for this report. This was him telling the world through his prism, what this report will entail. This is him putting a spin on this report before we've seen it.
One other way, Terry Moran, that the situation is indeed unprecedented.
It is unprecedented. This is the day that the conversation shifts, though, as I said, from was it criminal to was it right? And there's a big difference between what's lawful and what's right, what's criminal and what's wrong. And I think the conversation that a lot of people in the country are going to have as they make their way through this report is one that I think Barr wanted to meet with this closing argument he was making. He's trying to spin a little bit here and put in context what the American people are about to see for themselves, and it's admirable that he's going to release as much of it as he can.
And John Carl, as you reported earlier, there have been several conversations between Barr's team and the president's team.
There have, and we learned from Barr here that the president's personal counsel actually was given a chance to read the entire report sometime over the past couple of days. But George, there certainly is a fair amount of spinning going on all sides of this, but we are just in the opening rounds here. When this report comes out, as we heard from Barr, there will be 10 episodes. He says 10 episodes that were described by Robert Mueller and the special counsel that raise concerns, possible obstruction of justice concerns. So while we have, Barr's take on this now, we've heard it fully. These 10 episodes will be something that the White House is going to, White House will have to explain. So we have the president declaring victory. We have some opening spin here, but make no mistake, this is a lengthy report that is going to be published largely unredacted. That will go chapter and verse into the president's actions that, in the opinion of the special counsel, raise at the very least serious questions of whether or not the president obstructed justice. That's a big deal, and that's much more than what we've heard so far from the Attorney General.
Barr said largely unredacted. One of the big exceptions to the unredacted portions are this grand jury material. I want to bring in Mary Bruce for more on that as well. We already know, Mary Bruce, that the chairman of the House Judiciary Committee, Gerald Nadler, has said he's prepared to subpoena William Barr and the Justice Department for that material if he believes Congress needs it.
Yeah, and George, they have that subpoena card ready to lay on the table, possibly as soon as tomorrow. Look, Democratic sources that I've been talking with just over the last couple minutes say that this was the first they have heard of any briefing or any unredacted version of the report that's going to be provided to members of Congress. Now, the Attorney General there said that it will, of course, have limited exceptions for the grand jury material, but that's not going to be enough. Chairman Nadler has made very clear that he feels that Congress has a right to see that grand jury material, that he believes there is precedent for that, and he is, of course, willing to go to court to fight to get it. when it comes to the question of obstruction of justice here, George, Democrats have made very clear that not only are they going to want, every little detail, but especially they're going to want to see Mueller's own words on this. They're going to want to be able to compare Mueller's words to Barr's summary. It's one of the many things that they are hoping to glean today as they read through this report, speed read it, along with the rest of Washington. But from what they just heard from Bill Barr, Democrats that I'm hearing from initially say it doesn't change a thing for them.
Not yet, it doesn't. Dan Abrams.
And what are the legal theories where they disagreed? Right? You heard Bill Barr refer to the fact that there were certain legal theories where they disagreed when it came to obstruction of justice. What are those?
Well, one of them could be, was there an underlying crime?
Right. And the question becomes, he's basically trying to make us believe that they were generally in agreement on a lot of things, but it does seem that they were in fundamental disagreement. And if they were in disagreement, then why would Robert Mueller then be okay with the decision that is being made?
Well, and that's what I want to go back to another question, Terry, and I'll bring in Kate on this as well. You saw Barr use those words, unprecedented situation. I think back to previous special counsels. We heard from the special counsels.
Yeah.
We heard from Ken Starr. We did not hear first from the Attorney General.
Different law. That law lapsed. The independent counsel law provided for the independent counsel to send a report to Congress. They rewrote the guidelines around investigations like this so that it went to the Attorney General confidentiality because Ken Starr's report was such a catastrophe. A lurid sexpose of a president, and probably did distract the country at that time. So they might have gone too far in the other direction, and they required the special counsel now to deliver that report only to the Attorney General, leaving it up to the Attorney General what should be made public.
Absolutely true, but one other important point, there's still a reason you get a special counsel. There's still a reason you go outside the Department of Justice to find someone. It's so that they can do an independent review. Yes, the person reports to the Attorney General, but the Attorney General is not supposed to really get involved. If they get involved in the process, they have to report that to Congress. So to just simply say, oh, of course Barr would come up with a conclusion here, that's not necessarily the case. The reason you have a special counsel is so that the Attorney General, who works for the president, doesn't have to make these sorts of decisions.
One of the other things, Kate Shaw, that we know is that William Barr had relatively strong feelings about this entire investigation even before he became Attorney General.
Right. He essentially auditioned for the job with a letter that said the president can't obstruct justice. And he's just gotten up in front of the country and said, look, lo and behold, the president didn't obstruct justice. And it's pretty convenient, right, that is sort of the way this is all played out. In terms of the difference between the independent counsel statute under which Ken Starr was appointed and the special counsel regulations under which Bob Mueller was appointed, the independent counsel statute required Ken Starr to make a referral to Congress if he found substantial and credible information that might constitute impeachable offenses, right? So the statutory framework that Mueller's operating under doesn't have that kind of language. So this report we're going to see today isn't in any way an impeachment referral in a formal sense, but whether in some sense Mueller did intend to sort of pass off to Congress the task of assessing what had happened, deciding whether all of that is consistent with the president's oath of office and his obligations to take care that the laws be faithfully executed. That may be where the sort of action shifts to after today.
Well, the action is starting to shift already. Mary Bruce, I want to bring you back in here because we're already hearing now from the chairman of the House Judiciary Committee saying they want to hear from Robert Mueller.
Yeah, the chairman just sent a letter saying that Mueller needs to testify on the Hill no later than May 23rd. In a tweet, Chairman Nadler says it is clear Congress and the American people must hear from special counsel Robert Mueller in person to better understand his findings. We are now requesting Mueller to appear before the Judiciary Committee as soon as possible. George, prior to today, Democrats had always said that calling Mueller up was a possibility. It seemed they were going to hold off on that until they saw the redacted report, until they heard from Bill Barr, who's set to testify on the Hill May 1st and 2nd. But it is clear that the way that the Attorney General has handled this rollout has pushed Democrats to take this additional step. We heard this morning from Democratic leaders Chuck Schumer and Nancy Pelosi. They made very clear, they said that Bill Barr was acting in a way that was indefensible, that he was planning to spin the report. They said that his behavior had resulted in a crisis of confidence in his independence and impartiality, and that in order for the American public to restore faith in this investigation, that Mueller himself has to come and testify before Congress.
Okay, Mayor, I want to bring in Matthew Dowd as well. You saw that phrase, restore the faith, in this entire investigation. It does seem like the public's views on this entire investigation, on the president, on whether or not there was any improper cooperation with Russia have been pretty hardened.
Oh, they were hardened, and that 3.5-page letter that Barr put out didn't move the public at all, didn't move more people for the president or more people against the president. It's pretty firm, and my guess is, in the aftermath of this, I was struck, George, by watching this and listening to Bill Barr, how much he put his own credibility on the line, it seemed, in order to spin for the president and to give the president basically what's going to amount to is 2 hours of better press. He put his own credibility on the line. And as you watched him do that, excusing the president on his emotional or mood state related to obstruction of justice, he felt more like, to get back to a Game of Thrones reference, he felt more like the Hand of the King than he did the Attorney General of the United States. And I think we're going to see, when the report is fully read, how big the gap between what Bill Barr just said and what the report actually says.
And that's a big question, Terry Moran, is, I mean, because it would be quite a gamble for the Attorney General to go out there and give a press conference like this if indeed there were significant gaps.
And I think that's one of the reasons the president's supporters are so confident in him. He's 68 years old. He's been Attorney General. He's got a reputation. Would he really throw it away for this? Now, he looks at the law and at the power of the president very differently, in a way that's very favorable to President Trump. He did write that letter saying that the president has these authorities and that the law can't apply to him, essentially. That is not universally accepted. Bill Barr has a legal opinion that is favorable to Trump, but whether or not he would sacrifice his character, which he'd spent decades building, he's not a Trumpy.
And so much of that will depend on whether Robert Mueller also backs him, not only in the writing of the report, but apparently when he comes to Congress later in May.
Right. No question about that. But can we just take one step back and talk about how crazy it is that we're sitting here for an hour without the report? I mean, we just heard a press conference from the Attorney General who's laid out for us everything that's in the report, how it was done, et cetera.
It was delivered in late March.
Right, delivered in late March. And here we are, and we have to wait another hour to get it. Why? I don't understand what could possibly be the reason that we need to wait after the press conference.
A report, mind you, that Barr said today he showed the White House and Trump's personal team of lawyers before the American public also got to see it.
So, I mean, there is simply, I mean, it's not the end of the world, right? Okay, so we have to wait another hour. Okay, fine. But there's just no way to justify it, except for the idea that Matt Dowd was just mentioning, a couple of hours of the president being able to respond and some good media.
Well, and that is clearly what Democrats are going to say about this as well. What you saw, Terry Moran, though, the Attorney General hang it on is that this is a different law and that he holds the ultimate responsibility under this law.
Right. It is clear that the law provides the Attorney General with the discretion in these matters. He turned it over to the White House because the president, as president, not as Donald Trump, but any president has the right to assert executive privilege. So they get a chance to take a look and see, is there anything in there? And there was nothing in there that they wanted to assert executive privilege on. The president's personal lawyers, that's a courtesy, but once again, traditionally done. So he is proceeding in a way that is helpful to Trump, but is squarely within what he views as his discretion as Attorney General.
So much will depend on if his words match what we all see in the report, which is going to be released to Congress at around 11 a.m. to the public shortly thereafter. We will come back once we've had a chance to look at that report and report on Robert Mueller's words. Our coverage now is going to continue on our live channel. We'll be back in a minute.
This has been a special report from ABC News.